Hello everyone and welcome to today's session on the access to digital assets. Um, Project that has been approved by the ELI Council in 2019 after a feasibility study that was performed in the years before. Um, the aim of this project is to facilitate the position of those entitled to digital assets. And in this project, we are focusing on private individuals, and we intend to facilitate the position of those who more and more frequently have to deal with digital assets in their daily legal practice. And then we are talking about judges, we are talking about notaries, but for example, we are also talking about enforcement agents. And with regard to the last profession, my name is Jos Uiterhaag. I am an enforcement agent, a judicial officer in the Netherlands, and I'm also the secretary of the International Union of Judicial Officers, UIHJ, which is one of the founding members of ELI. If we talk about the project, and the panelists will go further into detail, it has to be mentioned that on purpose we have chosen for a very broad composition of the project team. On the one hand, we have scholars, we have professors at law from various universities, not only from within Europe, but also, for example, from South Africa and from US. On the other hand, we have representatives of the legal professions. We have lawyers, notaries, judiciaries, and of course, enforcement agents. We have experts in legal reform, and we also have experts, representatives from the banks, being that, for example, the European Central Bank, but also the Land Register. On purpose, enormous broad composition of the project team, because if we talk about digital wealth, it is very heterogeneous. We talk about digital assets, we talk about emails, we talk about photos on mobile phones, we talk about software, we talk about ebooks, we can talk about cryptocurrencies, gaming equipment, online financial accounts, loyalty programs, online storage, social media, etc., etc. I can continue for another half hour just to mentioning these digital assets. So today we are going to discuss the development so far within the project, a very challenging project. So I'm very honored also with the speakers that I can introduce to you today. I will introduce them when they do the presentation. Before we start, just an organizational remark. All microphones for the participants are muted, so should you have any question to the panelists, I request you kindly to use the question and answer, the Q&A function. This Q&A function will be enabled during the webinar, and you will that way be able to ask your questions to the panelists through this chat function. As a first speaker, I would like to give the floor to my dear friend and co-reporter in the Digital Assets project, Professor Chef van Erp. Chef is a professor of civil law and European private law at Maastricht University. He has also a very broad experience when it comes to digital assets. When it comes to blockchain, he's also the chairman of the blockchain project team of ELI. He is a deputy justice of the Court of Appeal in 's-Hertogenbosch, in Den Bosch. He is a member of the American Law Institute, founding member and former vice president of ELI. And I can continue for another few minutes. Chef, thank you very much for your participation, and I would like to give you the floor to tell a bit more in detail what the aims of the project are.
Thank you very much, Jos, and thank you very much for your kind introduction. And it's a pleasure doing that. I will do that on the basis of a brief PowerPoint. And essentially, the PowerPoint is more of a nature of updating and also explaining some of the, let's say, the doubts we have, the difficulties we encounter, and also to explain why this project, like the blockchain and smart contracts project, take time, perhaps more time than anticipated at the beginning. And they take time because thinking about the legal consequences of the rapid digitalization of the world around us is not really an easy task, and answers are not just ready. We need to rethink the applicability of certain rules, rules which are written for the real world around us, but can they be applied in the digital world, and so on. And what we do in this project, as you explained, we focus on digital assets. And we do that from a perspective, very basic legal perspective, that we look at subjects, so persons who want to have information about these digital assets. We look at the object as such, so what are digital assets, and you gave several examples. We look at the right that this person claims regarding these objects, so what does access mean in this particular situation? And we also look at this from the perspective of purpose. So why do you want information about a particular digital asset? It matters whether the person asking access is a bank, or a private person, an heir, or a judicial enforcement officer. The rights to access are different for all of these persons. It also may matter which type of digital asset we talk about. Are we talking about a crypto asset? Or in an inheritance, are we talking about a collection of digital photos, for instance? It's a complicated area that we are facing. So far, the part that is most advanced concerns the use of digital assets as collateral for a loan. And later on, during the panel, Phoebus Athanasius will talk about that. But let me explain to you a few of the problems. Now, the objects that we are talking about, digital assets, well, digital assets, of course, are clearly closely related to other developments in the area of IT, particularly blockchains and smart contracts. Because what is happening on a blockchain, where a smart contract running on a blockchain, is that they create digital assets. So this project is closely related to the ELI project of blockchains and smart contracts, which means that coordination has to take place regarding, for instance, definitions. Now, the definitions do not necessarily need to be identical, but they need coordination. And for instance, several members of the group on blockchains and smart contracts have made several comments to me about the definition in this group of digital assets. And of course, these comments are taken into account. At the same time, in the blockchain group, what happens in the digital asset group is also brought forward, again, to reach coordination. And next slide, please. Right. And this point is quite tricky and very difficult. And personally, I would be very interested to hear from those of you participating in the webinar what you think. The project is about access to assets. So gaining information about assets, about digital assets. It is questionable whether you can actually separate access from assets, in the sense that what this group does not want, and what the Uniform Law Commission in the United States that drafted a model law in this area also did not want, is we do not want to make statements about the legal nature of digital assets. So can you own a digital asset, or is a digital asset just governed by contract law or tort law? Or is it outside the law? Is it neither property nor contract? Then what is it? And when you say that you can own a digital asset, and that term is used very often, what do you mean by ownership? Is ownership then the same as ownership of land? Well, obviously not, but then what is it? What we see happening at a European level, that access is more and more equated with management. So you manage an asset, and part of management is gaining information about it, gaining access. So a major question is, can you separate questions concerning access to digital assets from who is entitled to the digital asset, what is a digital asset from a legal viewpoint? We see here, of course, a mixture of technology and law that is reflected in the definitions, and it is definitely reflected in the definition of digital asset or the definition of token. Now, with regard to digital assets, within the project team, there has been quite a debate on whether a digital asset can only be something of economic value. Now, from the perspective of digital assets as collateral for a loan, it's clear only those digital assets are relevant which have economic value. But when you talk to notaries, they say, and we all can understand that from our personal lives, that there are, in a succession or in a matrimonial property regime or a registered partnership regime, several assets with hardly or no economic value, but which have emotional value. And certain assets that might even be far more important than assets that represent money. And also these assets which have emotional value, well, heirs should have access. So here you see again that it matters from which perspective, from which person you're looking at these questions. An heir has a different view than a bank or than a judicial enforcement officer. So how do you define digital asset? We tried to find a good definition which basically balances the technical aspects and the aspects from which the question is asked, should a particular person have access, yes or no? That same mixture you see in a term like token, a digital representation of reality. A token can represent, for instance, a share. Technically speaking, a token is a digital document, a digital unit, but it is used in such a way that it has legal consequences. So again, you see that we try to define tokens in a mixed technological, legal way, and that can be quite complicated. Next slide, please. The focus of this project is somewhat different from the US model law, because we also target, as I mentioned, digital assets which are part of community property. So either as a consequence of marriage or as a consequence of registered partnerships, or digital assets which belong to a succession. What we understand is from notaries that there is an absolute need for some guidance, and the purpose of this project, like of the project on blockchains and smart contracts, is that we try to formulate guiding principles which support practitioners, banks, but also particularly judges, in how to decide cases in case problems come up concerning access, concerning digital assets. But again, we want to stay away from debates about the nature of digital assets, because opinion there differs considerably. So marriage, registered partnership, succession, use as collateral for a loan, and seizure in the interest of creditors, seizure by judicial enforcement officers. Suppose you have a judgment saying that a debtor must pay his creditor. There is a seizure of all that debtor's assets, and part of the assets are cryptocurrencies. What can you do? What sort of problems do you encounter? And there we are still discussing, because how can you seize something if the currency is on a public blockchain and you cannot find a person whom you can approach for seizure? Are there ways around this? should you then look for custodians, intermediaries? But what are your rights then with regard to the custodian and towards the intermediary? Next slide, please. The structure of our principles so far is as you see on the screen. But I must tell you that we are constantly thinking about revising the structure. And I can also say that when I presented the progress to the ELI Council, the suggestion was made to split up the project and perhaps first focus on the use of digital assets as collateral and present a report on that together with the more general part, and then continue working on succession and on seizure. As you can see, we also have draft principles already on applicable law, private international law. And that, of course, is, well, let me use the word tricky. I mean, there is debate about the law that should, the rules that should govern digital assets, smart contracts, and so on. Which law, the law of which state? Should it be supranational? So which law applies here? Should we draft autonomous rules, for instance, in Europe? Should we have rules which decide which national law to apply? We made an attempt, but of course, again, you face problems with regard to, for instance, public blockchains. Which law governs the Bitcoin blockchain? You can only decide that when you have two parties, a party and a counterparty. You need humans or legal persons. And a blockchain is not a legal person. There is no address, physical address. There are only cryptographic addresses and so on. And so far, we have a part on categories, persons, and then transfers inter vivos is about the use as collateral, marriage, succession, and force of law is about seizure. So this is the structure for the time being, but as I say, it is in constant change, and we are seriously considering splitting up the project and perhaps publish a first report and then a second report afterwards. Next slide, please. We do this within small working groups within the project team. So regarding private international law, the principles were prepared by the private international law experts in the group. The same with regard to the use as collateral. The same will happen with regard to marriage and succession. And with regard to transfers by force of law, of course, we cooperate closely through my co-reporter Jos Uiterhaag with the International Union of Judicial Enforcement Officers, and we want to use their comparative knowledge in this area. Next slide, please. To summarize, I tried to give you a very brief progress report, an overview of where we are, about debates, and about the very difficult question, can you separate access from the legal nature of the asset as to which access is asked? We think you can. It's a very pragmatic approach, but personally, I would be very interested to hear from those of you following this webinar what you think. Thank you very much.
Thank you very much, Chef. I think you made some very good points in that respect, that digital assets, they can be considered frequently as the outcome of new technologies, and that's why the link with the other projects, for example, the blockchain and smart contracts project is so much of importance. At the same time, we see, and we will also hear that from the other panelists, the importance of drafting of guiding principles. It seems that everybody is waiting on the development of such kind of principles in order to create a common understanding, in order to have more clarity on what are the basic rights of those entitled to digital assets, and also in order to facilitate the work of the legal practitioners, as I already mentioned, the judiciary, the lawyers, the notaries, the enforcement agents, etc., etc. Our next speaker, Phoebus Antanasio, he will go into more detail in what kind of discussions did we have on the legal topics within the project. Phoebus is a legal counsel of the European Central Bank. We are very happy that the ECB is also participating in our project. He's a member of the faculty of the Institute of Law and Finance at Frankfurt University. He has a PhD in law from King's College in London, qualified lawyer, and what is very important, he published extensively with regard to financial services, with regard to fintech, with regard to the use of IT in the field of banks. So Phoebus, the floor is yours, and maybe you can explain more about the conceptual and practical complexity of a project like this.
So thank you very much. Can you hear me? Thank you. Well, thank you very much for making me sound more important than I am in your introduction. I have to apologize in advance for repeating in slightly different words some of the points that Sief made in his introduction. This is because I feel those points I will go over again are quite significant, and they merit being gone over again, so that we can all understand what exactly it is we're aiming to achieve and what tools we're using to be able to achieve it. Now, Sief mentioned that the emphasis of the project is on digital assets, and in particular on questions of relevance to access to digital assets. So quite naturally in approaching our work, the project members, we've all struggled with definitions. And in particular, we've struggled with defining first which digital assets fall within the scope of our work. Secondly, what types of access we aim to regulate. I'm not sure regulate is the right term, but I suppose you see what I mean. And thirdly, what sort of use we would hope the principles we will eventually draft might be put into. So what I will do in the next few minutes is to go over these three points, and then I will wrap up my my introduction with some thoughts on the fourth point, which Sief has already touched on, and which I and I suppose many of us within the group consider to be of some relevance to our future work. So let me then start with the first of the three areas of interest for the work of our group, and this is the definition of its subject matter, let's say the concept of digital assets. Obviously, this definition, this concept, is central to the principles and central to the work of the group. It's a starting point for our reflection, and it's not surprising that it's only relatively recently that we arrived at a definition that does not have to be all-inclusive, but should nonetheless, and we think does, fit the needs of the project. Now, the definition we've opted for, it places the emphasis on 3 attributes that an asset has to fulfill so as to fall within the remit of our work. The first of these attributes is its intangibility, as reflected in its electronic storage and processing. The second attribute is its transferability from one party to another, and transferability can mean inter vivos, by way of a voluntary disposition or by way of inheritance. It can also be a transfer that takes place at the instance of the owner of the asset, or by order of a judicial instance. The third attribute that an asset has to fulfill so as to fall within the scope of our work is value. And CF already mentioned that value can and will in many cases mean economic value, but it doesn't have to be the only kind of value an asset has to have in order to qualify for inclusion in the scope of our work. Another point that I think CF also touched on tangentially is the link between assets, digital assets on the one hand, and data on the other. Now, a digital asset will typically, possibly invariably, consist of data. But what we're looking at in our work is the digital asset. It's not the underlying data. Now, the types of assets that fall within the scope of the definition that we've come up with can and will include such things as digital currencies, other financial assets that may only exist in electronic form, tokens. They will also capture claims arising from smart contracts. They will capture assets consisting of derived data. They will even capture data that may be stored in social media or an email account. Personal data stored in social media or email accounts can also be digital assets, despite the fact that their content is consistent with what we would expect of a personal right, a priori excluding their transferability. But they nonetheless can be the object of succession rights, and there is, to this effect, recent case law in some of the member states of the EU. Now, our definition captures both a genuine digital asset and a digitalized asset. Now, a cryptocurrency or a digital currency is an example of a genuine digital asset, since a cryptocurrency will be created and will only exist in the digital world. Whereas, for instance, a security token can be an example of a digital asset to the extent that a security token is a mere representation of a real world asset and can serve as the functional equivalent of a bearer instrument. Internet domains and commercial social media accounts can also be examples of genuine digital assets. One final point then on the definition of digital assets is that the types of assets we're covering in the work of the group, they can be stored in platforms that may be centralized or decentralized, including platforms that may make use of blockchain or other distributed ledger technologies. It's therefore a definition which is in that sense technologically neutral. Now, a few words on the second area of interest of the group, and this is the question of the types of access that we have in mind. Now, the types of access will obviously depend on the type of digital asset each time at stake. And it may mean access to the value that an asset represents. It may mean access to the information society service in which the asset is stored. It may mean access to its security features that allow effectively control over the asset. Now, the scope of application of the principles, and therefore also the types of access we have in mind, are limited to the three areas that CF touched on already in his introduction. And these are the use of digital assets as collateral in the context of lending arrangements. Second, it's the condition subject to which a private person may succeed to digital assets. And a third area is that of the seizure of assets by order of a court. And there is, let's say, a common thread that runs through these three areas, and this is none other than their emphasis on the economic use of digital assets as repositories of value that can be monetized and exploited. And obviously, to the extent that they can provide a pool of digital wealth that is eligible for use in financial transactions or to satisfy claims of judgment debtors, digital assets embody a very considerable economic potential. And it is, I think, primarily this type of potential that we seek to unlock through the principles by proposing practical ways in which digital assets, as we define them, can be integrated into the financial system. Finally, on our, let's say, a third area of focus and interest in drafting the principles, this is the question of what kind of use do we expect those principles to be put into. And I think it's fair to say that our primary expectation and ambition is that the principles will be incorporated in private contractual agreements by the parties to those agreements. We obviously have, let's say, a secondary ambition, which may or may not be very realistic, and this is that the work we will conduct might provide a source of inspiration to legislators and help with the development of national and possibly supranational law, so that a shared understanding can come into existence in terms of how it may be possible to exercise rights of access over digital assets. But importantly, what the principles do not aim to do is to supplant existing legal prescriptions in this area. We understand them as being complementary, and for that reason, should there be a conflict or a contradiction between the principles and national law, to the extent that national laws exist in this area, then obviously it's the national law to which the parties to a contractual agreement or the agreement itself is subject that will prevail. Now, the principles we are in the process of drafting have to be consistent with, and they have to apply to digital assets that fulfill our proposed definition. They have to work for all three types of access that we have in mind, and they need to be drafted in a way such that the parties to private agreements feel that they can incorporate them by reference to their agreements. Now, all this is naturally quite challenging, but the success, the eventual success of the project depends precisely on the extent to which this challenge can be mastered by the members of the project. Now, before drawing a line, let me share with you a few thoughts on a question that, to me, and I'm sure also to other members of the project team, remains open, and that is a question of, let's say, private international law. It's to do with which law would apply to the question of access to digital assets. Now, our starting point is the idea that since we aim to make the lives of parties to private contractual agreements easier, those parties should be able to choose the legal regime that will also regulate the question of access to the digital assets that are the subject matter of their dealings. Now, this is undoubtedly a very fair starting point, but at the same time, if we accept that the primary aim of the principles is for them to be eligible for incorporation by reference in agreements, in those situations especially where national law either does not at all or does not exhaustively regulate the question of access to digital assets, then the question obviously arises whether and to what extent one actually needs some of the choice of law provisions that we have debated within the project group over the last several months, and which we have included in the current version of our work. Now, the obvious alternative to coming up with intricate private international law and applicable law provisions would be to designate as applicable law whichever law the parties to an arrangement have agreed upon, where national law is silent on the question of access to digital assets or to digital assets in general, or to designate as applicable law the law that applies to the particular access scenario each time under consideration, if and to the extent that national law regulates that particular type of access scenario and that particular type of digital asset. So I think it's fair to say that the question of identifying the applicable law is a question that remains open. It's the subject matter of debate within the project group. And I would not like, obviously, to preempt here the outcome of that discussion, but I think it reinforces the point that CF made in his closing remarks, that the way in which we approach our work and which elements we consider to be essential in order to come up with a cohesive group of principles is something that has been changing over time. As those of us who decided to participate in the work of the group realized the magnitude and the complexity of the task that we have in some cases inadvertently undertaken. So I will draw a line here, and I thank you for your attention.
Well, thank you very much, Phoebus. It is a challenge, and it will remain a challenge to discuss the principles also in future. I would like to give the floor immediately to our next speaker, Yannick Menesseur. Well, I already mentioned my organization, the International Union of Judicial Officers, of Enforcement Agents, and we are an observer at the various committees of CEPES, the Commission for the Efficiency of Justice of the Council of Europe. And on those occasions, we many times already met with Yannick, and for sure, Yannick will have some challenging remarks with regard to this topic. Yannick is a French magistrate seconded at the Council of Europe and assigned as an advisor within the Council of Europe when it comes to digital transformation. He contributed to comparative analysis of European judicial systems, developed expertise in the field of digital transformation, in particular with regard to the regulation of artificial intelligence. And I think one of the results was also the ethical charter for the judiciary that was adopted last year, December, by CEPES. So, Yannick, the floor is yours.
Thanks a lot to Josh, and thanks a lot to invite me to give some thought. Just as a short introduction, I do not work anymore in the CEPES, so I won't represent them today, but now I am in charge of studying what are the impact of digital transformation on human rights, rule of law, and democracy. And that framework, I hope I can share with you some thought. Just to start, I want to mention that there is already an impressive work, and it seems for me very relevant. I think this work is expected by professionals, and I, former magistrate, judge, I think that my colleagues could be very interested to have more clarity on that topic. Because when you mention that definition, tangibility, transferability, value, I think it works quite well. And even for non-specialists, and for sure, I think a lot of legal professions are not specialists of digital tools, I think it works quite well, and we understand clearly what are really the challenge. If I take the example, for instance, of a token, I am not sure that this is absolutely crystal clear for a lot of judges or etc. So there is a huge need of vulgarization and explaining exactly what we have to understand by digital assets. I think that a lot of colleagues, when they hear that kind of word, blockchain, token, I don't know, all that artificial intelligence, I think the immediate connection with need of judicial expertise. And not because they are lazy, but just because they do not have the knowledge. So everything that could help to have a clear framework, I think is important. And this is another important point. As is, I think that there is a need maybe of some new regulation, but I will tell some words just after that. My first thinking, and I will have 3 points. The first one is about what can be done at constant flow. I think we imagine that in this digital world, we always need new digital rules to apply with. And maybe the first thinking, and this is my first reaction, is to see what we can obtain from our actual law framework. And if you think about that, I think that the first issue is that if you apply consent law in such an innovative domain, you can have disparate national solutions that could emerge from the jurisprudence of the court at national level. And again, it could lead to need of expertise. I want to underline here the important role of judicial expert in that field, but it will take time. And I think about the duration of court case, and we have to also facilitate that and try to reduce that. The second thing, I think that there is already some well-known mechanism for accessing digital assets, and we can. I have also in mind the use of these digital assets when it comes to evidence in a trial. And I want to underline here the guidelines from CDCG at the Council of Europe about digital evidence. It has been published just last year, and this is, in my opinion, a very interesting document where it examines the potential property value of, for instance, metadata, also how to manipulate that, and one important thing also of how we can manage distortion or erasure of this electronic evidence. Because in digital world, you have to be sure that, of course, this digital information is not modified. So there is a clear need of categorization of this asset. I think you have done that, and it's again quite relevant. And at the same time, you have to be technologically neutral. Phoebus mentioned that, and I think we have to think that technology will evolve. Of course, now, which is trendy, maybe a little less more, it's blockchain, but we have to think exactly in this evolving world when you can do that. So the idea to do not necessarily reinvent the wheel and also take care to not weakening current legal architectures that have acquired a robust internal logic. A short point also about the choice of the parties for the applicable law. Phoebus mentioned that, and it seems quite relevant. This is the will of the parties to find and designate in what jurisdiction they want to see their case goes, but take care also of the risk of forum shopping. It must be think about a mechanism that should take care of a balance between parties. If I am a simple citizen versus a big tech company, I am not sure that I will have the full choice to choose my court, and this big tech company could prefer a court that is favorable for her needs. Last thing about what can be done at consent law, this is also a question of making operators, social networks, for instance, responsible by inviting them to set up a system, for instance, of delegates. I think that Facebook, for instance, has already done something like that, where you can designate a delegate if you die. And also, there is a simple mechanism, and I will be pleased if you challenge that view, but you can also read a simple will, give that to a notary, and with some information, grant the access to, in inheritance case, to the person that you want. This is my first reaction and the first thing that I want to share with you. The other thing, and I try then to explore another path, is the use of technological solution for digital assets, meaning how you can use technologies in a digital world. And I think that in that respect, it's a good idea, but there is some precautions to be taken. This is Nathalie Frisero that published in this well-known book that you know maybe, this digital assets and enforcement. She proposed in that book something interesting. She said that if you have a Tesla, for instance, then you can imagine to use an electronic then virtues. You send an information to Tesla and your car does not work anymore. So this is a possible application. You can also imagine that the immobilization of crypto actives by banks could be carried out in the blockchain itself through smart contracts or any other technological possibilities. And to go in a provocative way to the end of that kind of proposals, why not an artificial intelligence that could be in charge of forced execution? So this is purely fantasy and don't support at all that idea. But I think that there is a necessary presence of human being in the loop when there is possible important legal impact on individuals. The ideas of a trusted third party able, for example, of escrowing a sum of money and returning it in the event of execution of the obligation is very relevant. There are also questions of responsibility of professions, you know that better than me, Josh, such as bailiffs or also notaries, how to deal with that in digital world. I think that there is a strong need of evolution of profession, and policymakers can think about how to manage now training, changing of this profession, and not replacement by any other computer software. To conclude, I think that all of that must respect fundamental rights. You imagine that from my perspective in Council of Europe, human rights, rule of law are of course very important, and many rights seem to be guaranteed and either strengthened in this digital age. Privacy, dignity, non-discrimination. We are working now in an ad hoc committee on artificial intelligence in the Council of Europe. I'm working there. How to promote maybe a new convention on artificial intelligence. And I think we need that to be able to have clear rules in that digital world. The rule of law also, in my opinion, must be strongly guaranteed. It's not up to algorithm recording their decision in a blockchain to create a normative system. The rules in smart contract, for example, must continue to be intelligible, and the clauses must be able to be challenged in the light of the main legal principles governing contract law. And to conclude, I think there is a risk of drift where in a digital environment, the law will be replaced by calculation. This is clearly possible, meaning there is now just a simple algorithm that calculates a balance of interest between persons, and I think it's very dangerous because rule of law, it's law, it came from a democratic process, and I think that our legal corpus of fundamental rights is far to be obsolete and must remain a guide to the law and a guide for all of us. Thank you for your attention.
Thank you very much, Yannick. And it was exactly also those words that were mentioned yesterday by in the keynote speech of European Commissioner Didier Reynders when he was talking about the importance, the growing importance to guarantee the principles of the rule of law and the importance to guarantee the access to justice. And he called it the human-centric approach, as he mentioned it. And I think that still is of utmost importance. Our next panelist, Sir Geoffrey. He was a member of the UK jurisdiction task force that I cannot imagine that, but in just 6 months was able to draft a legal statement on crypto assets and smart contracts. I still cannot imagine that looking at the discussions that we have had already within our project. Sir Geoffrey was appointed as the Chancellor of the High Court of England and Wales in October 2016. He is responsible for the conduct of business in the Business and Property Courts and presides in the Court of Appeal. He's editor-in-chief of the White Book, a member of the UK government's Law Tech Delivery Panel, and chairs the UK Jurisdiction Task Force. And so Geoffrey, maybe you can also explain how you were able to draft such a legal statement on crypto assets in such a short time. The floor is yours.
Thank you very much, Jos. Well, I probably won't do that, explaining the timescale of the UK Jurisdiction Task Force, but I will try and make a few comments about this project in some fairly short order. I think the first thing is that the project is, on its own admission, tackling procedural rather than substantive law issues. And that is no doubt not only because, but also as a result of a range of substantive law approaches in European municipal laws to succession, matrimonial property, partnerships, the giving of security, and court seizure of private property. So on that basis, the principles that we're looking at in the draft relate to applicable law, the categories of digital assets, the categories of persons having access to digital assets, and the use of digital assets as security, and transfers by force of law, which may take place, as we now know, by artificial intelligence, as Yannick has reminded us. But in the few minutes that I have, I want to cover some general observations, the attempt to identify an applicable law to the question of who can or should have access to different categories of digital assets in different situations like death, marriage, partnership breakup, or the enforcement of securitization contracts. I want to cover the utility of categorizing different types of digital assets in this context and say a few words about the broader picture. But start with general observations. The use and value of digital assets is rising exponentially. It's not an exaggeration to say that the world's data is now far more valuable than the world's oil supplies. And it's for that reason, and this does come back to what Jos was saying in the introduction, there is little time to work out a new set of procedural rules to decide how to deal with the transmission of different species of data and crypto assets, to name but two. The ship has in fact already sailed. Individuals and businesses around Europe are already dealing with these questions on a daily basis. They have to. And in many cases, there are already very large price tickets attached to the consequences. So lawyers can't afford the luxury of navel gazing. They must be brutally pragmatic and creative. And what is needed is a set of simple principles. Those principles must be intuitive, and they must be of general application across municipal systems. On analysis, I think we will find that the problems are not quite as complex as they may at first appear. And here I give two examples. One is the one mentioned by Jos. When I chaired the UK Jurisdiction Task Force, which produced its legal statement on the status of crypto assets in smart contracts in 6 months at the end of 2019. It provided an authoritative statement that under English law, crypto assets are capable of being regarded as property, and smart contracts are capable of being regarded as contracts. Lawyers across common law jurisdictions had been agonizing about those two questions for years before it was published. But the statement clarified two critical legal aspects in a very short timescale. And in the last 9 months, that statement has received widespread acceptance across common law jurisdictions. And a second example of doing something quickly is in a recent case that I heard in the English Court of Appeal, the case of Lloyd against Google, we determined that browser-generated information collected without consent by Google from 4 million citizens had a value, had a monetary value, and was property under English law. Now that you might think is obvious, but it's extremely important nonetheless. So what these examples show is that there's an urgent need for clarity, simplicity, and harmonization in this area. Individuals and businesses do not want to be told that the legal position is in doubt or complex. They want to know that they can do what will seem absolutely obvious to everyone. For example, that the heirs to a deceased person can access and deal with their digital assets, just as they can access and deal with their physical assets. They need to be told, for example, that their digital assets can be disposed of by their testaments, just as their physical assets can, and that their valuable digital assets can be securitized, just as their physical assets can. A word about the applicable law. Everybody's spoken about it. To lawyers, this is a question that provides endless fascination and complexity. The conflict of laws has always been one of the most tricky academic legal subjects. The principles correctly state the obvious, namely that the parties are free to choose the legal regime that will apply to the access to be given to their digital assets, and that the courts of a party's domicile will otherwise generally have jurisdiction. As the comments in the draft, however, effectively acknowledge, many, if not most, digital assets are stateless and borderless. They are not, in common understanding, located anywhere. A Slovakian accessing her Facebook account in Rome will not be able to say where that account is located. Crypto assets recorded on the borderless blockchain are not properly understood as being located anywhere except possibly planet Earth. The data collected by Google from all of us may be recorded on their servers in California, but it may actually be stored anywhere and moved at the stroke of a key. Thus, the regime of what law is applicable to accessing digital assets must be simplicity itself. It must be the law agreed between the parties, or the law applicable to the legal process in contemplation, such as domicile, succession, or divorce. And these principles are a classic example of what needs to be intuitive, simple, and workable. Complexity must be shunned. And judges and lawyers should be trying their hardest to persuade those using digital assets to choose the law and forum by which they wish the legal right to access their digital assets to be governed. Dispute determination and jurisdiction clauses need to be agreed between the parties to smart contracts and on-chain transactions involving crypto assets. The same applies to consumer access to digital assets such as social media, music rights online, and YouTube. So I come to the categorization of digital assets. Once again, I would advise simplicity and intuitive solutions. The key, in my opinion, is to ask first why one needs to know which category of digital asset is concerned. If the question is asked in order to establish who should have access after death to a deceased's Facebook account, the solution must find favor with the legal regime of both the proprietors of the Facebook product and the law of succession applicable to the deceased estate. But it must also be intuitive. If the question is asked in order to determine who can assert a right to be forgotten, the answer is again obvious. It can only be the person in question or their legal successor. Providing too much legal complexity will lead to differences between legal regimes across the world, when what is needed is pragmatic and accepted harmonization. There is no time for me to discuss difficult suggested distinctions between provided data, observed data, derived data, and inferred data, and how relieved I am about that. But once again, in this area, lawyers and judges need to be urging those using digital assets to choose the law and forum by which they wish their categorization to be determined. Finally, the broader picture. This project is much needed, but it cannot be confined to Europe. As I've tried to suggest in the course of this short contribution, the data boat has sailed, and people are dealing with these questions pragmatically every day. Of course, a deceased's heirs can access, indeed sell, the data owned by the deceased, whether it's photos on their Facebook account, crypto assets, rights under a smart contract, or a library of digital recordings. But Europe can't operate on its own when the digital assets we're talking about are borderless and stateless. Principle 1 under purpose, definition, and scope, of course, already makes that point. The individuals and businesses owning digital assets, data, and associated intellectual property have habitual residences and domiciles, but the solutions we adopt in Europe need to talk to, and equally important, align so far as possible with those in Asia, in the United States, in Canada, China, Africa, and South America. I haven't had time to descend into any detail, but I think the project is an extraordinarily valuable one and is certainly proceeding in the right direction. I would urge the team, however, to keep some of the broader factors in mind as they proceed. It is sometimes tempting to dwell, particularly for lawyers, to dwell on the technical detail when the obvious and pragmatic solution is staring you in the face. Thank you.
Thank you very much, Sir Jeffrey. We have a number of questions already, and if I may, the first question of Christian Twig-Fleschner. Have you considered the limited parallel with uncitral model law on electronic transferable records, where the notion of physical possession of a bill of lading, etc., has been substituted with the notion of control over the electronic records? Access seems to do pretty much the same work for this project as control does in the model law. And maybe also connected with that is the remark that Jan Erlang, one of the project team members, made. Access and control definitely have an overflow in meaning, but it is easy to have differentiated approach between the two. You can give one person access without control and another access with control. As such, control is the ultimate form of access. Almost as in ownership in property. Maybe, Chef, you can make some remarks about this?
Yep. Yes. The difficulty with all the terminology here is that we are giving it a new meaning. So we are defining what does access mean, what does control mean, what does erasure mean, like the right to be forgotten. What does it mean? What is its effect? And what I gradually see happening is that, as Jan writes, control, in fact, means the most complete, well, power over data. So you have access, so you can get information about it, you can change the data, you can transfer them, they can be ported, so you can take them with you from one provider, for instance, to another. So control is gradually becoming a sort of all-enveloping approach, an all-enveloping notion. Access is not so much about control. Access is about gaining information, knowing what there is. And then the other questions are, well, if you know what there is, what can you do? What are your rights? What are your further rights? And I must say, of course, I was quite familiar with the work by the task force that Sir Jeffrey presented. And I think that the only approach here in this area must be very pragmatic. And it's also procedural. In the general principles that we drafted on private international law, you see that these principles are fairly procedural in nature. So let's say the first principle is which court has jurisdiction And of course, traditionally, you then look at the law of the court of the defendant. But if there is no defendant, why not the claimant? And if the claimant is a consumer, you cannot expect that consumer asks for access to a Google account in California, because then the right to access is pointless, because no consumer will start litigation there in case Google refuses. The fact that we have all these cases against Google is that Google, Facebook, others have establishment in the European Union, so you have a counterparty within the European Union. So my reply would be, yes, we do look very closely at what is happening at other levels. We do look at concepts like control, but we also see happening that there is a gradual understanding about what control in these initiatives means. And for us, access is first of all gaining information about whether there is a digital asset. So is there a bank account and so on.
Yes, Sir Jeffrey?
May I say something very quickly? And that is that it seems to me that control is about a de facto existence of control, whilst access is about the right to access digital assets. And therefore, they're really rather different. And one is not in any way the same as the other.
Thank you. Then there is another question from Sergio Camara. Since the definition, Phoebus, maybe you can answer this question. Since the definition includes as a feature the capability to be transferred from one party to another, and you include as one instance of digital asset the social media accounts, does this mean that depending on the contractual standard terms of the provider of the service, an account will be transferable or not? And then he explains, I am thinking of the possibility to post-mortem access once the title holder of the account is dead. Have you considered the possibility of distinguishing between digital assets and digital services for this respect? I find it difficult to apply the very same rules to assets such as tokens, cryptocurrencies, licenses on music and so, and to contracts that define services.
Yeah, I think the short answer to the first question is yes. Now, the second part of the question raised by the colleague is, I think, a very legitimate one. It's possible that because of my background, I have an interest more in what one might call, let's say in general terms, a financial asset, and I have less sympathy for the inclusion within the scope of the project of data of the type that might be stored in a social media account, which is, I think, the example that the colleague came. And the reason why I have less sympathy for the inclusion within the scope of the project of what one might call generically personal data is precisely the reason that the colleague who's asking the question decided to raise it. But what applies to an asset in the, let's say, the financial sense of the term surely cannot apply to personal data such as the one that would be stored in an account. And one of the reasons why I think we within the group we have a tendency to place the emphasis more on assets that have economic value is I think on the one hand it's to do with the fact that we see their economic potential and we want to ensure through the principles that this potential can be realized. But let's say the other reason is that the sort of data that would be stored in a digital account is rather different animal to currency, to tokenized security. And it is indeed difficult, not impossible, but difficult to craft principles that would apply to equal measure to both of these types of animals. So I think it's a very legitimate question, and we've debated within the group on that question at length, and I think it's a question that will keep occupying our minds until the end of our work.
Thank you very much, Phoebus. I think the other question was already answered in your presentation. Do you take the view that something like an electronic link to someone's bank account is a digital asset and to be included in the study? But I think you already answered, Phoebus, in your presentation, this with the distinction with digital assets and digitized assets. Let's see, maybe we have time for one more question. Another question here is, as to private international law, how might one formulate a rule as to applicable law to access to digital assets without having decided on its legal nature? This question is from Gudula Dijpenbroek. Sorry if I pronounce the name wrongly. Maybe, I don't know who would like, Chef, maybe you want to answer this question?
Well, maybe it would be really interesting hearing what Sir Geoffrey says.
Okay.
Given that your report, if I'm not mistaken, has already been followed, well, you mentioned it, but has already been followed in case law. So there are cases, I think there's even a New Zealand case, if I'm not mistaken, that is basically following what you proposed. So personally, as a co-reporter, I would very much like to hear from you, if I may.
Excellent. Sir Geoffrey?
Forgive me. And I think it's quite difficult probably to formulate these rules without having decided on the legal nature of what you're dealing with, which is why we started in England with the legal statement, because we didn't think that we could, people could deal in confidence with digital assets unless they knew that municipal law, at least, would regard them as property. And if they were not regarded as property, I mean, there are, the status of data is also very difficult. And people have raised in this discussion whether there is value in personal data. But Google will tell you that the value of personal data is absolutely huge. For example, Google's browser-generated information, in other words, the data they collect every day, because they now ask you whether they can, and most people say they can, as to what you search on their database, is fantastically valuable to advertisers who want to deluge you with advertisements about things you're interested in, not things you're not interested in. So personal data, and even the photographs that people store on Facebook, are of fantastic value to commercial businesses. And therefore, one has to start from the proposition that what you are dealing with in terms of digital assets and data and crypto assets and smart contracts and everything else is that they fit in to some municipal law box. Now, I suspect the common law will be different from civil law in the sense that we judges can actually, you might say, make it up as we go along. We would say apply historical legal principles so as to reach a conclusion quickly without having to have legislation. But it may be that there will be legislation in this area in many countries, and there already have been in many countries or some countries up to now. But the answer to the question is probably it's very difficult to decide about rules for getting access to digital assets unless you know what they are as a matter of law. But it's pretty obvious, the answer, in many, many cases. And that's actually all we said in the legal statement. But we had a problem under the common law because there'd been some rather difficult cases historically at a high level that had given the impression that data was not property and that crypto assets wouldn't be property. And then we have, I'm sorry to bang on, but the great and interesting question of intellectual property, which is indeed property, but of a different kind. So I think the answer to the question is you can't, but the answer to the question is also that we need very quickly to start at the beginning with identifying what is the nature of digital assets concerned, and then we can move quickly to the rules in question in this project.
Thank you very much. Maybe Yannick, you want to add something here?
No, I won't add anything to Servo's statement. It's perfectly clear, and indeed, maybe in common law and continental law, we can have some different views about that. But I keep in mind that, of course, it's important to be able to, in almost maybe all case, to see what is the legal nature. But in another case, as I mentioned, with a simple Facebook account, I think there is already applicable law, and even if we don't decide exactly what is the legal status of Facebook account, you can delegate that to someone else with a very simple view. So, sorry, my answer may be quite naive and simple, but let's back to basics every time before creating new laws. This is only the thing that I want to state.
Thank you very much. I think, Yannick, this is also a very nice conclusion, because I think that was something that all the presentations of the panelists had in common. And well, I think it was Jeffrey who said the ship has in reality already sailed, and we have to deal with these issues on a day-to-day basis with these questions, and we cannot afford the luxury of navel gazing. I like that expression very much. We have to be brutally pragmatic and creative, and this is also, I think, the challenge also towards the future within the project. So I would like to say thank you very much for the contributions, first of all, towards the panelists, also on behalf of the whole project team, Access to Digital Assets. Thank you very much for your contribution. Also, thank you very much towards the participants for joining us in this webinar, and we hope to see you the next time.